Hello, everyone, and welcome to our webinar today. We are just getting started, so I will let a few people in, give it a few more seconds, maybe 30 seconds until we officially start. Very good. Looks like people are still getting in. Well, welcome everyone to our webinar today, 5G patent race leaders and the road to 6G. My name is Tim Pullman. I'm the Managing Director Americas and also the Director of SEP Analysis at LexisNexis. I'm joined here today by three great expert speakers, but before I'm gonna present you those speakers and introduce them and discuss with them on the latest trends, I'll kick off our session today with a few slides about our latest 5G report. Before I do that, some housekeeping rules. You will see the M&A box, which allows you to ask questions. I will monitor those questions during our discussion, during the webinar, and I will read those questions and share them with our expert speakers. Apart from that, we're planning today to have a 60-minute session. To keep it interactive, we also planned 3 poll questions, meaning questions we address to you, the audience, which are multiple choice, so you can click the answers. And I will also share the results of what the audience feels and how they answer to those poll questions. So you can see a little bit of a trend of the market. We have over 100 people here live already. I think over 250 registered. So I think it's a good group of experts that we can pull from. But to get started, as many of you know, on Monday last week, we published the 2026 5G report with LexisNexis, and I want to give you just some highlights. The full report is publicly available. You can download it on our website. You can search it. Typically, you'll find it quickly there. And it has a lot more statistics as of what I show you today. I just give you some highlights. But let's start with the trends. People sometimes ask me, hey, Tim, 5G was developed in 2015. I'm sure the standard is set and we don't see many more patents. But what we do see, in fact, year over year, there are more patents coming into the landscape. Whether or not these are all essential is debatable, of course, but there is still a lot of activity in developing 5G further. And of course, 5G Advanced was introduced in the latest release. And that you can see also in the data. What you see here is a bar chart by the year of publication of the patent families. It's only active and granted patent families across different jurisdictions. And you see that compared to last year, we had another almost 15,000 patent families added to the landscape. And the years before also, the numbers were increasing year over year by 10,000, 6,000, 7,000, 8,000 patent family every year. And we're only looking at granted patents. I can tell you there are a lot more patents that are still pending. We have a similar activity when we look at the technical contributions submitted to the 3GPP meetings. And we're monitoring these contributions submitted to the various groups. What we took into account here are only technical contributions, so we didn't count in editorial comments or agenda items. We tried to only count those that have a technical content. And also here I have to say the 2025 numbers are a bit higher now. These are original numbers from the report. But what the data really shows you year over year is that we have a massive amount of technical submissions at these meetings. And they even had to, I think, restrict the number of contributions that you can submit because it was so many. And also that confirms, yes, 5G is still actively worked on, or 5G Advanced now. And of course, that prepares already for the future when developing 6G. And we will hear more about that from our experts later on. Now, rankings. We also, of course, looked at the companies active and those who are, the leaders in our market. And of course, while we are ranking those companies in these tables, the opinion that I have, and this is also what we communicate with LexisNexis, is that we don't want to crown one winner. I think it makes most sense looking at the leaders. And the leaders that you see here are really representing most of the patents filed in the space, and they're also representing most of the technical contributions submitted. So what we looked at this year are 3 columns and 3 approaches to this. The first one counts all patents declared, active, and granted. The second one accounts for the technical merit. So the patent asset index is a value metric that basically tries to identify how valuable or how impactful the portfolio is. And that is calculated by the size of the family in the different markets. The markets are weighted by GDP. And the other factor is forward citations normalized by year and country. So we can compare patents from different jurisdictions. And the third column is the submissions of technical contributions. Again, we are fully aware one contribution doesn't equal one patent, right? There are contributions that are not even subject to patents. There are other contributions that may be subject to several patents. But it still is a good indicator to show these are companies that heavily invest into the standardization development. And those 3 approaches give you a good picture of who is among the top 10. And if you will ask me what were the top 10 last year, it's very similar. I think the leaders are strong and they're staying on top. But I can tell you, in the report, we have the top 50. There are a lot of shifts below that. Lots of new players that increased, and some other companies that are now in the top 50 that were not in the top 50 before. This year, we also refined and sliced the data a little bit differently. This is one example. We looked at declarations submitted, and as many people know, these declarations are declared to particular technical specification. And from the technical specification, we can understand which working group was responsible for these. And there are people who would argue that work that is done in RAN 1 and RAN 2, which is the physical layer core technology, that maybe those patents are also more core to 5G than patents filed for technology in other areas that are more marginal. So what we did is we looked at patent declarations across these groups to see if there's any focus and if certain companies file patents related to certain technologies, because what these groups in the end represent are technology topics. 5G is a very complex technology that you can, put into big different buckets and split into different topics and architectures. And this is what these groups represent. We have a similar analysis on these for releases, for example, but it allows you to basically, separate the data into different technology areas. Now, one thing that we again did, we made sure that the data we're using for the patent declarations is of the highest quality and is verified. And why is that important? Because the Etsy database, I think, is a great starting point, but the raw data in Etsy is not useful. The patents are self-declared, coming from very different companies. So you can imagine the format of how the patents are declared is very different. We often do not know if the number that was declared is a publication number, an application number, or even a provisional priority number. Those numbers are just declared in one. And therefore, there's a lot of possibilities that can go wrong when you look at the data. Mismatches, if you don't clean that, 40% will be mismatched. Even worse are false positives. We do see also a lot of patents declared by accident, maybe, that are just wrong patents. There's a famous Samsung patent, which is about washing machines and not about 5G. There is a famous patent from Nokia, which is about a necklace and not about 5G. Those patents made it into the database, but you have to clean them out, of course. And last but not least, you need to enrich that data with the latest ownership information, corporate tree information, but also a good understanding of which patents belong to which technology generation across 3G, 4G, 5G, and the bridging technologies in between. If you don't do that, and I just wanted to give you an example, the way that companies declare the patents is so different that also the error rate, meaning those patents that you wouldn't capture if you don't do it rigorously, would be very different from company to company. And I'm an economist. I would call this a systematic bias. What you see here is the number of patents that are not matchable if you don't, apply very rigorous matching of publication numbers. And Ericsson here is the highest. Ericsson declares a lot of their declarations as priority numbers. Those priority numbers are not typically easy to retrieve. They're not on the public registers. You have to connect these priority numbers with published patent publication numbers once these are published. If you don't do this, if you don't go the hard way and clean it, you are systematically underestimating the Ericsson portfolio. That's what this says. That means in many reports, 5G reports that I've seen, Ericsson is a lot lower of what the declaration actually is, right? So if you don't do this, it's not like you're missing in general a few patents that you didn't, match to the data. You systematically underestimate the portfolios of certain companies. And you see also here that other companies are among those. If the numbers are low, that means those companies declare very clean and very nice, but Etsy doesn't ask you that. Etsy basically asks you to declare, and then your obligation is gone, right? Another thing that is very worrisome is that the patent counterparts at Etsy are not accurately added, right? Etsy asks you to declare one basis patent, and then they're adding counterparts, but they don't do that across all jurisdictions. That means when you look at the data, even if you follow the Etsy family definition, they have their own patent family definition, almost 10,000 US counterparts or 7,000 Chinese counterparts are missing. Meaning, let's say you have a look at a landscape, let's say with a focus on China, and you're missing those counterparts. A US company that declared a basis patent in the US, the counterpart in China is missing, is underrepresented. In the same way, the other way around, if you look at the US landscape and a Chinese company that may have declared only the Chinese patent as a basis patent, the counterpart is missing, that Chinese company is underrepresented in the US landscape. So in summary, and we've shown that in other reports, you need perfect data to have an unbiased view on these landscapes. Otherwise, certain companies or certain jurisdiction underestimate the portfolio size. And that is why we have, last year it was 30, this year it's 35. We have contacted 35 of the Etsy declaring companies to check with us, is the data in our database representing what they have internally? And we're not verifying essentiality here. We are only verifying completeness and accuracy, meaning all the patents that you declared, that you think you declared to Etsy, represented in our database. And if not, then we try to match them correctly. And even if we do that and can't find the patents, we encourage those companies to redeclare at Etsy just to make sure that everyone's patent portfolios that is declared to 5G is also represented in the database. Because, and that's the reason why we do it, more and more of the companies that license SEPs and that determine FRAND use data to support it, which could be the top-down approach, looking at the different portions of ownership, but also in comparable license agreements, you have to understand, are these portfolios comparable? And to do that, you need to understand the size of the portfolio. And often, declaration data is the foundation, is the starting point. And a small percentage, if you think about the licensing, of large portfolios, it's about millions of dollars and millions of money. A small percentage may make, millions, right? If you're off by 0.5% and you use that as the foundation, there may be really big impacts on that. And one of our customers said, if the foundational 5G patent data is already off, every subsequent patent merit analysis could be distorted. So we are fully aware that our database only represents self-declared patents. No one has checked essentiality, but many companies use that as the foundation to then take samples, for example, check essentiality and make assumptions on that, right? And this is why reliable data matters more in SEP licensing than any other patent content. The data that we have put out there is and has been used across different courts. We only have the data here for the US, but I know it's been used in the UPC, in the UK court, in the Chinese court, even in the Japanese recent decisions where 5G data from IPlytics was referenced across different district courts, different jurisdictions. We did see that in many cases, expert testimony used our reports. And also what we have in the US, it's a Doebert standard. Basically, the judge has to make a judgment if the evidence is valid. And IPLIX data has passed this check from judges several times in the US. So we can summarize this data has been cited by judges, by different courts, by different authorities to be a starting point of FRAND determination and of SEP licensing. And I think the last point is most important. It has been put forward by both the plaintiffs, the patent owners, in the same way as the defendants, those who are implementing the standards and who have to pay a license. So it is data that is used across, the different players, which is important as we are a neutral source. With that, I would like to take over and hear from our great experts that we invited today. First, we have here Amy Yao, who is the director of intellectual property at ZTE, who is joining us today. We have Peiying Zhu, who is an SVP, wireless research at Huawei. And we have Aaron He, who is a licensing manager with Purplevine. And all three of them have expert knowledge in different areas. So I will be addressing different questions to each of them for the different topics that I would like to discuss. And also as a spoiler, as I said before, after each topic overview, I am asking you, the audience, about your commentary in a poll question. So I would say let's get started, and I will address questions to each of you. And I gave a very short introduction, but if you could also give us always 2 sentences of your current position and your focus in your work so that the audience gets some feedback, that would be much appreciated. And today I want to start with the first topic, which is about SEP licensing and litigation. Where are we now? And Amy, I would like to hear from you first. Where are we in global 5G patent licensing? How do you see the approach to this differing in different regions, differing across different countries? And how do you see in those negotiations how patent portfolios, 5G patent portfolios, are analyzed, evaluated, and assessed? What is your take on that?
Okay, thank you. Thank you for James' introduction, and first say hello to everyone online. And currently responsible for the company's patent prosecution, and including the SEPs and also licensing and also the litigations. So it's a brief introduction. Regarding the first topic you mentioned about the current trends of 5G SEP licensing, from my perspective, I think the most notable trend is after long-term development, the handset sector is actually established a relatively stable negotiation framework and also global royalty structures. So under which, although sometimes both parties in the negotiations may need some flexibilities, but overall the negotiations are normally proceed smoothly. But meanwhile, the current licensing negotiation has been rapidly extending to the vertical industries such as the IoT, the automotive, and also industry automations. As this industry featured diverse participants and also verified product forms and complex supply chains. So the licensing are still in the phase of continuous exploration. So besides to the licensing negotiation, we can say the first party mechanism such as the negotiation, the arbitration, and also the mediation are still very effective tools for the resolving the disputes. So we can say from public information that in recent years, the parties involved in 5G patent licensing disputes are increasingly extending to other industries, such as the automotive, rather than being very limited to companies in the telecommunication fields. So in short, as to the trends, I think the 5G licensing is expanding beyond the telecommunications, and the new scenarios and the issues triggered thereby are the current main trends. And second, I think you asking about how the 5G portfolio being assessed by the courts today. So firstly, as you just mentioned, the courts worldwide are commonly employ the comparable agreements method and also the top-down method to decide the rates. Under both methods, the size and the strength of the portfolio are the two main factors to be looked into. But in different judicial practice, the courts may have varying emphases. For example, in the applying the top-down methods, such as the Chinese courts, the number of declared patents is typically regarded as the more meaningful starting point to calculation, as many high-valued patents may not have been undergone the essentiality or validity examination, and thus the industry licensing is typically covers the entire declared portfolio to reflect the potential technical contribution to patents in the application. But in comparable scenarios, such as the UK courts, we can see the judge primarily relied on historical comparable agreements, consider the changes in recent portfolio from the time of the past license agreements to the trial, adjust the historical rates to reflect the actual value of the current patent portfolio. These changes include variations in the patent counts, such as the expelled or newly added patents, the changes in patent strengths, and such as the essentiality and the technological contribution, and also the generation evolution. So overall, in the comparable agreements approach, the rate is adjusted based on historical agreements, taking into account of dynamic changes in the patent portfolio. Top-down, however, is based on the number of the declared patents, the first establishing the overall communicative rates for the standard, and then determine the rates preliminary according to the number of the declarations. Maybe we cannot say which method is more reasonable or the best ways, but I think both the patent holders and also the implementers are expected to see more objective assessments of the portfolio. And I think that's why the data of the portfolio is more and more important for us. Yeah.
Very good. Thank you so much, Amy. That was a great overview of, the different dynamics and differences across courts, which is, I think, super interesting and makes this whole, licensing and litigation quite complex. If different courts have different approaches, you kind of, I'm sure you kind of have to plan ahead, like where you can expect what kind of outcomes of that. Over to you, Erin. Would be great if you could tell the audience you are, supporting companies in SEP licensing. Would be great if you could tell them a little bit about, the industry that you're operating in, and what your view is on licensing of SEPs. Do you see any trends? Do you see any different approaches of these different companies in the market across, the world, across jurisdictions?
Yeah, thank you, Tim. Well, depending on different technology fields, we represent both patent holders and implementers in license negotiations in China. And I can share some view into this Chinese market. And prior to joining Purple Vine, I also worked at ZTE for many years. So this has also provided me with an interesting perspective to look at this. So in China, what I observe as a recent development in licensing is the shift from the traditional mobile handsets devices to the vertical industries adopting cellular IoT. Now, our clients include automobile companies, point of sales companies, EV chargers, and smart metering companies. So you can see this is a very fragmented landscape. And many of these companies, despite having some substantial sales volumes, in some cases, have little or no prior experience with licensing. They lack the internal resources to engage in both the technical and business negotiations. So they sometimes only have a small IP team fighting patents and without any additional knowledge about licensing. So when we talk to these companies, the most frequently asked questions will be like, who are these companies that hold SEPs? Is there an overview of all the companies that may ask me for royalty? How much do I have to pay? I understand I have to pay for patents, but can I understand how much so that I can plan ahead and put it into our projections of the cost? So I want to give you an example. So a frequent situation these companies may encounter is when the implementer is negotiating with a patent pool, which sometimes does not provide a specific patent list, but only informing which licensors have joined the pool. So while the company is simultaneously negotiating with an individual licensor. So in this case, the company would ask, what is the licensor's share in the pool? And from the perspective of the patent quality, is the licensor's rate reasonable compared to the pool's rate? So these companies generally lack the capability to check these issues. So we have helped some companies to answer these questions. And I would say, as we often discuss, transparency still remains one of the biggest challenges for those smaller IoT companies in China. And that's also why I think reference information provided by platforms like Analytics is very valuable to the industry.
Great. Thank you so much for these insights, Iren. Also providing a bit of the perspective of the implementers. I think today it's interesting anyways, both ZTE and Huawei are also both big implementers in the markets, big handset business and base station business. So I think we have a good combination of perspectives here. But of course, the automotive industry is a new one, right? They're new to the game. And as Amy said, in the handsets, the players have been established over the past 20 years, right? This is a quite established market, but now we have new players in new industries, very competitive, where of course adding cost to this competition of price also is difficult, right? So I completely understand that. And of course, it's a complex world, right? We live in. I want to now hear from the audience because I have a poll question prepared about the topic of SEP trends in licensing and litigation and impact of different fields. So I will start this. The first question is, which trend do you think will have the biggest impact on 5G SEP licensing and litigation over the next 12 months? You can click, please. I mean, our experts here cannot, but everyone in the audience can. The first answer is increase in SEP litigation between major players. The second answer is more patent pools and defensive aggregators. Third answer is greater focus on royalty rate enforcement by courts. And the last one is stricter implementation of FRAND compliance and transparency by regulators. I don't know if you also have the last question cut off, but the last answer cut off, but the last one is about regulation. The third one is about courts. Second one about pools. And the first one about the bilateral negotiations and disputes of the big players. I'll give it a bit time. And during allowing you guys to answer, maybe we can go around the horn a bit of what you would expect is most impactful. But maybe back to you, Amy. What are your thoughts on this? What do you think is most impactful in the coming year?
Sorry, I just mute. On my first slide, I think maybe the SEP litigation will affect a lot. As we've already said, all the jurisdictions are very active in SEP litigations. Like China and the UK, they focus on establishing their FRAND rates to provide a more efficient resolution to the cross-border licensing dispute. And the German and the UPC court, they emphasize balance the injunctive relief with FRAND obligations. And also Brazil and Japan, they show new developments in their injunction relief. The Japan saw its first SEP litigation injunction case last year, while Brazil also see a very significant increase of their SEP litigations. However, the Brazil the courts may remain more cautious regarding preliminary injunctions, but we can see the trend that all the courts are very active, and maybe more cases will come out and change some of the rules.
Yeah, no, thank you for that comment. And I agree. Japan is interesting because Japan is a huge market. and there hasn't been any activity until recently. So I think it's very interesting to observe that. Iren, any thoughts? What would you vote?
Yeah, I think this is a single choice question. So I would say the first and the second choice I would also expect the increase of the SEP litigation, but also I would think more patent pools would appear because I think like we discussed the vertical industries will bring more and more implementers and players in, and patent pools is a solution to this situation, and it provides a simple solution for also small players. So yeah, but Amy has already addressed the first choice. I'll go the second choice.
Very good. I don't know if you see it, guys, because my screen is a little bit loading. I don't know why these poll questions are loading now. But half of the audience has answered. We have about 130 people live here today. I think we have answers from 65 or so. If you can see it, because my screen is loading right now with the result. So the first one, oh, now we can do it. Now it works. Can you see it? Now you should see it. So yeah, increase in SEP litigation, as predicted by Amy, is number one. Iren, also the pools have an impact, followed then by focus on royalty rate enforcement by courts, and then the last one is regulation. I think that one is least impactful. There's nothing right now also on the table of any regulation ideas. So I think for the next 12 months, that is a very true answer. Just for the audience, we have a great expert here, also from Huawei, Pei Ying, but she will focus more on the technical questions and answers. Just the reason why I haven't addressed anything to her, we will hear from her in a minute as well, as a little bit of a spoiler. The next set of questions is about the growing role of data. And of course, we discussed this already a little bit in my introduction. We are a data company at LexisNexis, of course, but data is, of course, not everything. So I would love to start and hear maybe from you, Pei Ying. You are going to those meetings, or you are in the R&D department of Huawei. You know the 3GPP is meeting. You know the innovation that you work on, and I think it's, if you're in the in-depths, of course, of technology, it's always very difficult to count patents and count contributions. But what are your thoughts on this? Like, you know, how do you see these statistics that we present?
Yeah, thank you, Tim, for inviting me for this discussion. I'm actually more on the technical side, as you mentioned. I was fully involved in the 5G research and standardization. Now I focus on the 6G research and standard. So from what you showed before, I think it's pretty much aligned with my observation or experience in terms of we look at people's contribution toward the 5G standard, and those on the top of your list, they are quite active in the technical discussion, and I think including have a innovative idea and so on. Of course, it's not necessarily aligned with all the aspects. I'm thinking, especially, I have some surprise for certain companies, but in general, I think the trend is quite aligned.
Very good. Thank you for that comment.
Yeah, thanks. Yeah.
Over to you, Amy. If you think about the use of data, right? Do you see anything? I mean, is it increasingly used not only in litigation, but also in negotiations? I think you touched on it already, but a little bit, the differences of the Chinese court, who look more into that data than, for example, the UK court. But what is your experience in general? I mean, you license global FRAND rates, right? You license with global companies. How often is data at the, how often is it used? What's the role of it? Has it increased in importance? What are your thoughts on this?
Okay, I think first we have to acknowledge that the availability of the data has greatly increased the transparency of licensing negotiations. We can say that not only the patent holders, but also the implementers have different source of data and also different type of sources, different type of data to put into the negotiations, which is actually help to increase the transparency of the negotiation. But on the other side, actually, I think if the definition of data fails to achieve the industry consensus, we may say the issues which negotiation complexity may increase. As we can see, differences also exist among various database and analytic institutions in definitions and also the measurement criteria, like the method for essentiality validation and the calculation of contribution weights. This can lead to discrepancies in data outcomes from different sources, which may prolong our negotiations and increase cost and also even trigger new disputes on us. So in short, we can see more and more data help us in the negotiations, but also the different data definitions and also the sources may cause problems nowadays. Yeah.
No, and that's a perfect comment, Amy, because we also have a question from the audience relating that. There's a question that, a comment from one of the people in the audience saying that there are differences in our reports at LexisNexis from last year. Samsung and Vivo both moved up. For example, China Mobile is now one of the top 20. Well, the question, of course, is, and it's a good one, is this really because they have more patents, or have we used a different way of counting them, refining the data? And I think both are true. I mean, just for background, at LexisNexis, we don't use every year the same metrics. We don't use the same way of how we split into different columns to basically tell the market there are different approaches to it. We don't have an opinion what is the best approach to account for it. Some like counting contributions, some like counting declarations, some like using different value metrics to kind of weight the counting of patent families. I would say, however, in most of the examples I see here, it is due to an increased number of patent declarations, especially in the case of China Mobile, who really picked up their game. They're like really a newcomer in the top region, because they have, I think, changed their approach to how they treat SEPs. But again, every data point, and I'm a data person, you have to be very careful and look at, where is the data coming from? What is the time period the data was looked at? What are the refinements? Are we looking into, is it a granted? Is it across all jurisdictions? Is it limited to certain jurisdictions? And of course, as I said before, certain reports also don't do a good job in matching these patents with a very rigorous way, right? So I would never suggest to look at the raw data at Etsy, use a professional provider, but even across the professional providers, we have differences too, right? So I think it's important to always be cautious when looking at data and understand where it's coming from. So that's perfect timing, perfect comment on this part. And then there's another question from the audience I think is interesting. It says, when reviewing 5G portfolios, you must be cautious. While release 15 contains most fundamental patents, subsequent releases like 16, 17, and others include more incremental ones, right? We actually have a report that we published in a couple of weeks on looking at the data across releases, because we have, mapped declarations to releases. And we also see that certain major players are very strong in release 15, while other players increase their ranking in later releases, which are more, I guess, on other layers. And I think Pei-Ying, maybe you can chime in on explaining what the differences are across those releases from a technical perspective. But I think slicing and dicing the data a little bit like this could give you some idea and identify some patterns, right?
Yeah, actually, it is true that I agree that the release 15 pattern are more essential in two sense. One is that usually the original idea proposed in the first release, so they have I mean, from my perspective, they carry a lot more. The more innovative ideas and so on. Then the other aspect is that typically the first release feature will be implemented in all products, while the other release, even though you see lots of feature defined, but they are not necessarily implemented. So from a litigation or licensing perspective, you have to consider whether this pattern are implemented in the product. Otherwise, they don't carry any real value in terms of licensing aspect. And the other thing I think also things change a bit is that in release 15, some company are active and they have been these newcomers after with a later release. So that actually probably changes this pattern landscape as well.
Perfect. No, that's a good comment. And, stay tuned. We will have some data on it in a couple coming weeks and add on our report, actually, because, refining the data in different ways makes sense, right? I think that is something I would recommend people to do, not counting everything together.
I may even add one thing. I always find, I'm speaking from a technical person's perspective there. I often find that actually the pattern used for litigation, sometimes they're trivial ones, which from my perspective, they're not even that interesting. But of course, it's easy to understand and easy to match to the standard and so on. But, that's
very good.
Different view.
Thank you, Pei. Thanks. That's good background. Iran, you haven't missed much. I know you were gone for a minute, but I want to hear your perspective on data. How important is data for your work supporting companies? How important is it that this data is verified and of good quality?
Yeah, sorry for I was disconnected for 2 minutes, but yeah, as for the both sides of the negotiation table, well, I think the patent data is definitely very important. The number of the patent families, the licenses share among all the SP holders, and the essentiality are all somehow the foundation of negotiating. And the data also serves as an important reference for the court to determine a FRAND royalty rate, whether with the top-down approach or other like hybrid approach. And I totally agree that the declared SEP data, the SE database, needs to be cleaned and verified. Otherwise, it will be misleading. So as an example, sometimes you may want to look at the jurisdiction coverage of the patent portfolio. And at that time, the raw data on the SE database might be misleading because of the SE IP policy describes the declaration of only one patent family member is required, meaning that all the other family members are also subject to the FRAND commitment. And the SE IP policy also requires the patent owners to declare their patents timely. So in practice, many companies will declare only the first filed patent family member at a very early stage, even when other family members have not been public or filed in other jurisdictions. So although the SE database is connected to the ISPASnet patent database, it will not automatically update the jurisdictions of the other family members. Also, the accurate legal status of the patents is also very important. Who is the actual patent owner, whether the patents have been transferred, whether the patents are expired, because this is directly related to the scope of the license in an agreement. Some of the terms might define the license patents to be the patents owned by the licensor, and some might define to be patents licensable by the licensor. So these are these subtle differences, and it should be carefully checked with an accurate data resource. Yeah.
Very good. No, that's a great comment. Thank you, Aaron, for your perspective here. And that gives me now the chance to also hear from our audience again. We have the next question. Let me quickly see how I can do that. I'm not technically versed. I'll try to get the next poll question. Oh, there it goes. So the next poll question is about data. How do you see the use of 5G patent data evolving in courts and SEP negotiation of the next year? A, increasingly relied upon to support royalty rate calculation. B, mainly used defensively in litigation, less than licensing. Or C, more important in areas where little patent declaration data is available, like Wi-Fi, video, audio, Qi, IoT. I'll again also want to hear from our experts, starting with you, Amy. What do you think? A, B, or C is most relevant, or what do you see for the next years?
I think the first and the third may also be the same important in the future. As the firstly, as we discussed, and the FRAND rates were based on the data, but also I think regarding to other technical aspects, maybe the data will help the new area and new the entities to know better about what they are talking about and negotiating about.
Very good. Any thoughts, Iran? What would you vote, A, B, or C?
Yeah, I agree. I'll probably choose C. I think C, at least for our projects right now, is very important because we all know that this Wi-Fi video audio patents as ESPs are under the so-called blanket declaration. So it's hard for the companies to estimate how many of them are there. So I also know Analytics is using some method to find them out. So I think this data information is very important now.
Very good. Thank you for that comment. And also, there was a question by a user. The WIPO has yesterday published data of pools, which are, of course, essentiality, vetted patents. We've been using that at IPlytics, LexisNexis forever, right? I mean, we added any pool list that is available. Wi-Fi is what I think the WIPO represented with Sysvel yesterday, but it's available for IoT. It's available for audio, video, for all of these, for G. But I think it's great to have patent pools out there, but they only cover 20, 30% of the market, right? I think the importance is finding the other 70% that are not out there. So from that comment, I think WIPO is doing a great job to put this importance of data availability on top of their agenda, but you need to look at the whole landscape. And that's what we're trying to do at LexisNexis IPlytics to, as Iran said, to do that, to find information across technologies that are not based on such perfect databases like Etsy. But what we see is, those questions are not, of course, mutually exclusive. So number one, increasingly relied upon in royalty rate calculations. And then the third one, more important in areas where we have little information. I think that is probably also, differ from industry to industry, but we have also new SEP licensing areas, maybe not as established yet, but especially if you think about video content, and these all, ways of licensing not only devices, but also video content. I think that data is really, really important. But this today is about 5G. So I think the results fit this. Very good. I want to go to our next set of questions, and this time starting with you, Ping. I've been observing, and you and I discussed this in our dry run call a little bit. I thought it was super fascinating. Everyone talks about these days, of course, about AI, right? And then we have seen, NVIDIA investing in Nokia. And there's this AI RAN, and the idea of deploying GPUs at these edge cases. And while all of this is, of course, the future, and we don't know what will be happening, I would love to hear from you, from an expert, a technology expert. What can we make of all this? How will AI impact 5G today and 6G tomorrow? And why would a company like NVIDIA be investing in the space? Because they're not the typical company that we have on the radar that is attending 3GPP meetings and owning SEPs or anything, right? This is that would be a completely new player in the market.
Yeah, actually, that is a quite interesting question. By the way, NVIDIA started to participate in the 3GPP standard, but maybe one or two people. But in general, I think for 6G, we do believe that AI will play a very important and significant role in this 6G standard. And I think we have been talking about the AI for network, and a network for AI. Basically, we use AI to improve the communication and improve the network management and reduce energy, reduce cost, and all this basically in general improve the system performance and operation. So that is for sure it will happen. It happened started to happen in 5G, and it will happen in 6G. The other aspect is also we're looking into how can we use the 6G network to support AI services. Yeah? So that is quite new, so from that perspective, if we can get certain AI services which require you to deploy them close to the edge or even on the every base station, then there's a possibility you can leverage this capability for the radio. But until that happens, if you just use GPU to run the radio, I don't think that is a good strategy. So far we have been trying to identify the use case to see whether there's a use case which makes sense to deploy at every base station, and also that will make operator profitable. That is a real question. It's definitely not a easy answer for this question. And so I don't want to comment on the whether it's a good strategy or not good strategy for Nokia to go with NVIDIA, but I think it's still from the RAM base station side, the radio side. We still see the importance to have maybe more dedicated hardware to do that. Mainly for few reasons is that you still need very short processing time, and also the power consumption at the base station is extremely important. The cost is very sensitive as well. So we have to look all these aspects. So I say it's quite unsure in this regard.
But very interesting. Thank you for your commentary, Piying. And I think we've seen that a little bit with the 5G rollout, which, by the way, in China is, I think, leading compared to Europe and the US or other regions, Japan and Korea. I think the operators have to make a lot of investments to have GPUs at local stations. So I think there have to be incentives for those to make those investments.
But maybe I'd add one more thing is actually on the cost side. On the other hand, we see a lot make a lot more sense to invest this computing power in that domain.
Yeah, I think it's just shifting costs from who is paying for what, right? Like, if you're wearing a smart glasses and the major part of computing is not your glasses but the edge, then maybe the glasses have to be cheaper and your 5G contract has to be more expensive, right? But anyways, this is my view as a consumer. Over to you, Amy. AI, the road from 5G to 6G. There's a question here also in the Q&A. Will we see even more patents filed for 6G? What is your view on this? Any ideas about AI and the world of patents and standards?
Okay, so from my perspective, I think the current 5G technology has transitioned from a large-scale development to deep applications, while 6G has entered into the critical phase of technical standardizations, also the integration of AI. It seems that almost all the companies are actively involved into the competitions, including the technology advancements and also standard development. Take ZTE as an example. We are actively engaged in research on potential key technologies for 6G, making significant investments into AI native, the integration of communication, sensing, and also computing. So while also contributing numerous standard proposals to standard organizations, nonetheless, I think the countries continues to compete for the core definition rights of virtual networks and our technical pathways for 6Gs. They are all remain uncertain. So I think maybe it's one of the reasons why the companies file more and more the patents to the declarations, because there are so much uncertainties. So as to no matter about the SEP strategies or the portfolio plannings, we are being more forward-looking and also more flexible to keep the competitiveness in the future. So I think maybe that's the reason for all the companies. They file more of the patents also for the declarations. Yeah.
Very good. That's very interesting. Over to you, Erin. Any thoughts on AI and how it influences SEPs?
Yeah, I want to mention that AI will boost many industries, not only about the cellular or wireless, but in other places, there will also be standards and the SEP. For example, the semiconductor. AI has clearly been driving tremendous growth in these companies, and we have already seen patent pools announcing licensing program that covers the semiconductor patents essential to the JEDEC standards. So if we look at a bit closer into what powers AI, we can see that this is likely to be a huge growth. And IP litigation in these areas is also increasing. So I think it's only a matter of time before the market becomes a place similar to what we see now in smartphone. And with respect to the AI technology itself, I would say there are different places where AI is used, and there are different types of AI patterns. So with respect to the training models, I think at this moment, most of the companies would agree that it's better to protect them as trade secrets, because obviously the training models and algorithms are not open, and the companies want to keep it to themselves. As we know, in the traditional standardization process, the larger companies with a lot of resources would work with the standard body, and there is obviously incentive for them to share their technologies to make it available for others to use. But it is different when it comes to AI. On the application level or device-based level, there could be some patents claiming the interactions process, like how a device or automobile car use the training data. But I also think these claims need to be very carefully drafted to make the infringement detectable.
Yeah, very good. Thank you for that comment. Very good. Very interesting. Last but not least, I know we are almost at the time, but I want to hear from all of you about really 6G and the road ahead to 6G. And I think one big question most of the people have, and also here in the audience, is what will 6G look like? And will it change the scene of the industry? Will we see many new players like NVIDIA's, or can we expect that major companies like the Huawei's and ZTE's will be among those still and remain the ones that will develop that next generation? So Pei-Ying, what are your thoughts on 6G? Even though it's a little bit crystal ball still, but what are your expectations there?
Yeah, I think for 6G, we started standardization like at the middle year of the last year, and we have a initial scope defined. So from standard perspective, we see the 6G will have maybe two major aspects. One is, of course, cellular connectivity is a major aspect, and we will provide the better connectivity in terms of uplink throughput and better user experience and so on. Of course, we have targeted centimeter wave, more like around 6 to 7 gig spectrum, and we have a wide frequency to band to use, and then that will give us more capacity and so on. But also as mentioned, that native power consumption for both terminal and base station will be one of the day one, key design features. There's also the design principle that day one will actually cover the entire device category rather than previously we designed the mobile, high-end device, then trying to reduce the feature to cover the low end. So this time it will be designed as a whole. But aside from that, of course, we will use, people talk about the native AI, as I mentioned, we will enable the network automation and so on. But in addition to the better connectivity, I think 6G will provide the beyond the communication services like integrated sensing and communication and network for AI services and so on. So these are quite new compared with 5G. And I think this will make a significant, shift. Hope that will offer, more revenue opportunity for the operators. But from the player perspective, I think still I see the traditional terminal and the base station vendor are playing a key role in terms of defining the 6G standard, and of course with operators as well. There are some new commerce, I mentioned before, like this. We see some people from Google, some from Nvidia, but their effort comparing with the other, traditional vendors are quite smaller, much smaller. Yeah. So I think from a pattern perspective or technology, the contribution perspective, I expect the similar to 5G. Yeah.
Very good. So, I mean, someone has to drive this huge technology forward, and I think, the most experienced ones are best in place. I want to start a poll question around it, and I also want to then ask Amy and Erin on what they think. But the last poll of today, because we're at the hour, is as we move forward to 6G, how do you expect the next generation of wireless technology affect landscape of patent holders? Will it A, significantly reshuffle the current 5G patent holder landscape? B, some new entrants, but major 5G holders will remain? Or C, too early to predict? We heard Pei Ying's commentary on it, that she feels that new players come in, but of course those who have been shaping 3G, 4G, and also 5G are probably also those that shape 6G. Amy, what are your thoughts on this 6G and who will own those patents?
Yeah, I think it's maybe too early to predict, but I think there must be new players in the industry. Yeah.
Very good. Erin, any thought on 6G moving forward?
Yeah, I agree with Amy, and I think it's still too early to predict the 6G patent landscape, and we'll wait and see.
Very good. Let's see what our audience says, and our audience actually believes some new entrants, but major 5G holders will also be the major ones for 6G. So they apparently don't think it's too early, even though 6G is not even out there. Just to mention that, I mean, Pei Ying was commenting to it, so we really don't know anything yet. But I think many people feel, right? I mean, you started 6G work. The companies at these meetings are the companies that have been at the 5G meetings, right? Why would suddenly NVIDIA be in our top 10 of 6G patent holders? Very unlikely, right? So I think that makes sense to me, even though we don't know much like how 6G will be designed. And since we're at the hour, guys, I want to shorten that a little bit because I want to hear your final statements. I think it's always great in a discussion like this that all the experts can maybe give a final statement of, a few seconds only, what you want the audience to remember from our discussion, if that is okay. And maybe I'm starting with you, Pei Ying. What do you want the audience to remember from the discussion today?
Yeah, actually, for 6G, we're targeting, the service, the commercial deployment beyond 2030. And if you look at the today's AI advancement, we actually believe that we probably need to design the 6G system better to serve this AI application. Maybe in the future it's no longer called application. Maybe it's more like a agent talking to agent and so on.
Of course.
So I think those aspects we need to think about, and also we need to think about how we can leverage this new capability in our design. So these are quite important. We cannot just say, okay, let's do another generation, with a slight modification stuff like that. That's what I believe.
Very good. Thank you, Piying. Amy, what do you want the audience to remember from today's discussion?
Okay. As the 5G licensing and also litigation becoming more and more complex, and I think the evaluation or assessment of the portfolio will still and always be the core issues of the negotiations. So I think both as data is both the implementer and also the patent holder, we hope the both parties can reach some consensus on how to use the data to help to build a more efficient and cost-effective negotiations to reach the consensus. Yeah.
Very good. That's a great comment, Amy. Thank you. Iran, what's your final remarks?
Yeah, I want to quote a line from a movie that I really like. It says, "It's a complicated world." The licensing market in China is broad but complicated because the technology has brought so many different players into this game, and every vertical industry will have their own consideration and situations. And the global SEP litigation is also complicated now because of the competition between different countries and jurisdictions, which requires us to think about the strategy in a global mindset. Well, it's complicated, but that's also the beauty of this job. So I'm optimistic about the future of this market.
Very good. Thank you so much, guys. I think we heard great commentary from all of you. Piying, thank you for giving us a perspective on 6G when it's coming. Amy, I couldn't agree more. In the complex world that Iran very well describes, we need transparency and alignment on how to value and be efficient, because it's increasingly complex and we can only solve it with simplicity. I hope some of the data we provide supports that. I also put a link again in the chat for our latest report in case you haven't read it yet. And watch out. We will have some follow-up reports analysis coming out. Thank you for joining us today. Please, a silent applause to our expert speakers. I think you did an excellent job. I learned something new today, which is always great to hear from them. And stay tuned. Thank you for joining us and hope to see you soon. Take care and goodbye.
Thank you.
Thank you. Goodbye.